Hi, this is Kelsey Vokowski for APGov Review, and in part two, we're going to be looking at civil liberties, dealing specifically with the First Amendment and dealing with freedom of expression. It is really a fine line between, are these amendments, such as the freedom of speech, are they absolute? Can they be restricted to some degree? And that's really what we're going to be focusing on here. So a term really dealing with censorship is known as prior restraint. And in a case in 1931 known as Near v. Minnesota, you had a newspaper publication criticizing government officials, calling them Jewish gangsters, and the government prevented that material from being published. So the censorship actually happened prior to this. And this is going to be ruled unconstitutional. Now, what's interesting about freedom of speech and the press is that at times in history it has been permissible during wartime, especially dealing with national security. But again, that's even a little bit of a gray area even today. Now, it's important to note that one may be punished after something is published today, not so much before it is published. And then another landmark case dealing actually with students. It's known as Tinker v. Des Moines. This is when two students are going to be suspended after wearing these black armbands with peace symbols to protest the Vietnam War in school. And they ultimately, of course, are suspended, and they challenge their suspension. Basically, at this time, I mean, think about what symbolic speech is. It can be anything that is not verbal, but basically conveys what you're thinking or would normally say. Prior to this point, you had other forms of symbolic speech, such as if you're going to wear a pro-life shirt. That's an example of symbolic speech. Now, what's important is that the court is going to rule in favor of the students because some speech was not restricted. So you can't just discriminate based on the type of speech, symbolic speech that is. And this is going to establish what is known as the Tinker test, named after the case. So it's similar to the Lemon test, and oftentimes you have these tests that come out of the majority opinions, and in this case it's no different. So in the Tinker test, the basic question becomes, does this interfere with the operation of schools? So students' rights are somewhat restricted a little bit more because they are in an institution, and the purpose is, of course, for learning. And anything that becomes a distraction can be censored. However, wearing these armbands, is that necessarily going to distract from the educational mission? And the court is going to use this as a test and say, no, it's not. And it is going to, of course, rule in favor of Tinker. So that's a very important case. Now, a case dealing with the First Amendment, dealing with freedom of press with respect to students, is going to be restricted a little bit in 1988. And this is when students begin in their newspaper, as student-run newspapers are, write some controversial articles dealing with teenage pregnancy and divorce. And the school steps in and begins to censor it because they say, you know what, this isn't appropriate for the stuff being written. And the students are going to, of course, bring this to the Supreme Court. And the Supreme Court is going to rule against the students, citing that if the school sees legitimate pedagogical concerns, they are allowed to censor this. And of course, these would be topics covered in health and phys ed education. So this is going to set a strong precedent. Notice too that this newspaper is not student funded. It is actually funded by the school, the taxpayers. So this is going to, of course, set a very strong precedent against students' right to speech, or specifically press. Now, dealing with other cases in free speech and public order, there's something that's going to be known as the clear and present danger test, and this is going to be established in Schenck v. U.S. in 1919. And this is when leaflets are going to be distributed around World War I, urging men to not join the draft and not sign up for it. And the court's going to rule, and of course take the context of it in 1919, is that speech can be limited because it poses a clear and present danger. Now, fast forward to 1971 with the Pentagon Papers case dealing with Watergate. It's going to say, you know what, exposing corruption with Richard Nixon is indeed not going to create a clear and present danger. So think of it in this light. If you're at a movie theater, it's dark, and you yell fire, well, that's going to create a clear and present danger. So your speech is going to be restricted. So you can't just yell fire. You can't just yell, cause a false alarm. People could be panicking, running for the fire exits, getting trampled in the chaos. So this is going to be a case that's going to be established here in 1919, Schenck v. U.S., but it's not going to apply in certain issues such as dealing with the Watergate scandal. Now, what's interesting to note is that it is permissible to advocate the violent overthrow of the government hypothetically. However, to incite someone to create lawless action that's imminent, that would be against the law. So, it works better in theory than actuality, but nevertheless, this is something that the courts are still continuing to deal with cases that, of course, are ongoing. So, generally speaking, speech is most protected in public places, but if you're in a private space, certainly you can be kicked off because that is not your private property. So if you're in a public space or you're on your own property, you are more than allowed to basically say, for the most part, what you want. But if you are on someone else's private property, those rules do not apply. Okay, moving on with free press and fair trials is extensive press coverage of high-profile cases such as O.J. Simpson, Martha Stewart permissible, and ultimately this comes down sort of to a First Amendment but also a Sixth Amendment issue that the public has a right to know what happens. That's why you see such high coverage of these cases, not only high-profile cases but also local cases if you look in the local newspaper. It's also important to note that the press, their own sources, may not entirely be protected. There have been times where journalists have actually been held in contempt of court, held in jail until they reveal their confidential source. Some states do have shield laws that protect these reporters, but in other states they do not. So it really does vary in what state you are working in. Now, dealing with obscenity, what's interesting is that there's no clear definition on what constitutes obscenity. Justice Stewart once said he defined pornography, for example, and obscenity. I know it when I see it. And that was sort of the definition there. And the landmark obscenity case deals with Miller v. California, stated that the materials were obscene if the work appeals to a prurient interest in sex, showed patently offensive sexual conduct, and lacks serious literary, artistic, political, or scientific value, that would be deemed as obscene. Now, again, this is going to be contingent upon local community standards. So if you're going to use obscenity, right, what you deem obscene, let's say in Las Vegas, is going to be a heck of a lot different if you're in a very conservative city, such as, let's say, you're in Montgomery, Alabama. They would probably be a little bit more conservative and strict in their definition of obscenity. So again, it's noted that it's very much contingent upon to where you are, because again, it's very difficult to have a consensus as times change. What you compare today versus the 1960s or 50s, it's a lot different. If you've ever seen the show I Love Lucy, you'll see that Lucy and her husband sleep in different beds. It was too taboo to put them in one bed. Yet if you turn on MTV today, you see a heck of a lot more than that. So certainly that has changed. Now, dealing with libel and slander are both very similar, but they're a little bit different in the sense of how they are communicated. Libel deals with the publication of false or malicious statements that damage someone's reputation, as opposed to slander, same thing, but it's spoken instead of printed. So libel is going to be written, whereas slander is going to be spoken. And statements about public figures are libelous only if made with reckless disregard for truth. Dealing with higher public figures is really hard to deal with slander. I mean, if you look at politicians today and what is said about them, if it's false, it's still very hard to prove slander. Whereas if you're making these vicious lies up about a regular, ordinary person, that can be a little bit easier to prove in court. So again, private individuals compared to the public figures have lower standards to meet to win libel suits, but it's not necessarily impossible. Now, dealing with an obscenity example, Reverend Jerry Falwell sued Hustler magazine. Hustler depicted Falwell as having his first time in an outhouse with his mother. Falwell sued over the emotional distress and mental anguish. Now, it's important to note that Hustler magazine, known for being sort of a tabloid magazine, purposely did this, was doing it to be satirical. And ultimately, the Supreme Court is going to rule 9-0 in favor of Hustler magazine because, again, you are a public figure, and even though this is outlandishly false, it still does not meet that definition of libel for a person of this nature. So again, it really depends on if you are a private or public figure. All right, almost finished up with this. So dealing again with symbolic speech, we talked a little bit about it in the beginning. This is just nonverbal communication. So if you're wearing an armband, like in the Tinker v. Des Moines case, or what happens if you're burning a flag. And this is a very, very controversial issue. Courts have ruled, dealing first with Texas v. Johnson in 1989, that burning the flag is symbolic speech protected by the First Amendment. And you saw a lot of this during the Vietnam War. You still see a little bit of it today in the United States. But keep in mind that it is protected. And while it is controversial, you have had some states that have actually banned it at a state level, but it would never hold up in a federal court unless they overturn the Texas v. Johnson precedent. Now, it's important to distinguish between burning a flag and, let's say, burning a cross. The difference is a cross is not protected because its sole purpose is to intimidate, as opposed to a flag where it's supposed to be more about protesting the government as opposed to a specific class of people. So there is a very important difference there. It's also important to note that burning a flag in a very hazardous way, that, let's say you have gasoline around you, let's say you're doing it at a gas station, that of course would not be protected. So as long as it's done in a safe manner, you are theoretically, and not just theoretically, but dealing with the law, you are protected by the First Amendment. All right. And dealing with communication in the form of advertising, this is actually the most restricted and regulated form of speech as per the Federal Trade Commission and also the Federal Communication Commission. So that's why after a certain hour or certain time of the day, you're not going to be hearing curse words when children are most likely to be watching. And you'll notice that as the later that you watch television at night, then you begin to see some more inappropriate content come about. And failing to abide by these rules set by the FCC, you can certainly be fined. For example, Howard Stern has been fined $600,000, probably even more since this time. Again, the regulation by the FCC has to be tailored to promote a compelling governmental issue or interest, such as allowing sexually oriented content between 6 p.m. and 6 a.m. So the regulation does have to be justified. It can't just be arbitrary. It has to be specific and have a specific interest, and that, of course, is shielding the innocence of children.